In this lesson, looking at legal and evidential burdens, we're going to continue to just talk through this process that exists when we talk about the ways in which these burdens are essentially distributed across the prosecution and the defense. We're going to talk about the circumstances in which the evidential burden might be placed onto that of the defendant in this case, in this lesson. So these are going to be the circumstances in which we have a legal burden and an evidential burden, and where these two things split. We're also going to be reminding ourselves of the basic principle of the presumption of innocence, as cited in the case of Woolmington versus the Director of Public Prosecutions. We'll talk about that case, we'll talk about the influence of the idea of the golden thread principle, and we will think about some of the defences that places an evidential burden onto that of a defendant. And then in the next lesson, we're going to talk about the impact of the Human Rights Act and the European Convention on Human Rights in this particular area of criminal evidence law. Whereas in most cases there is a connection between the legal burden on the one hand and the evidential burden on the other, this is not always the case with the splitting of these burdens across multiple parties. So, what are the circumstances in which a defendant might have an evidential burden in a criminal case? Well, the two circumstances are the following. Firstly, where there is a raising of a common law defence on the part of the defendant. Secondly, where there might be statutory defences that are raised as well. Let's begin with these, okay? Common law defences. What common law defences exist? Well, if you're somebody who has come from my lessons on the subject of just the criminal law, the ordinary criminal law, there are quite a few common law defences. The main common law defences include things like, for example, self-defence, which does have some statutory implementations. So there are some statutes that sort of help to define the idea of self-defence, but self-defence is generally seen as a common law defence. The common law defence of automatism, for those of you who don't know, for some reason, who are studying criminal evidence before studying criminal law, automatism is a defence whereby the sort of body is acting and moving and doing things without the control of the mind. So, for example, a muscle spasm that has no connection with the mind or any kind of conscious thought would be considered to be an example of automatism. Often cases, there's a famous example of automatism. For example, if you are a rugby player and you get knocked unconscious, there are some circumstances in which you are knocked unconscious, but you are still running. If you then go and run and hit somebody or assault somebody, that is not your fault because, of course, you are not acting consciously. It is seen as something that is separate, however, to the idea of insanity and the defense of insanity. So bear that in mind as well. So non-insane automatism is sometimes how it is defined. Intoxication or drunkenness is also a defence that is a common law defence that can lead to an evidentiary burden, a standard that is then placed onto, or at least a burden, that should I say, that is placed onto the defence. And then finally, the common law defence of duress, acting under a sense of duress. Often, most common, this is duress by threats, i.e. somebody threatens serious bodily injury to you or to a loved one, and that forces you to then commit some kind of act, to commit some kind of crime in their control. In each of these cases, the defendant will have an evidential burden, and I should note that there are common law cases that establishes that fact. There are cases that establishes the fact that in self-defense there is an evidential burden, in automatism there is an evidential burden, or intoxication or duress there is an evidential burden. I didn't go through and I didn't put all of those cases onto this particular presentation. If you want me to do a presentation where I go through each of the cases and cite the authorities that show this, do let me know, and I will. Some of them are cases that we have already talked about in the lessons on criminal law. So, for example, the case of Bratty versus Northern Ireland is a case that we see looking at the defence of automatism. But if you want me to do those, let me know, and I'll put some lessons together to do that as well. But for now, let's just think about other issues as well. So, the thing that's really important in all of these cases is that where there is a common law defence that is raised, like automatism or duress or intoxication, whatever, okay, the is only an evidential burden that is placed onto the defendant. They have to prove that they have to show that they were intoxicated, or show that they were acting in self-defense, or provide medical evidence that they were unconscious when they performed whatever muscle spasms, etc., etc. A point of importance that should be noted, however, is that the legal burden still remains with that of the prosecution. And this takes us all the way back to the case from 1935, of Woolmington versus the Director of Public Prosecutions. Because this is where we get the famous golden thread quote relating to not only the idea of the legal burden, but also the idea of the presumption of innocence. So, it provides the most substantive case law on the matter of presumptions and burdens. And like already, if you have already studied the lessons in the criminal law, you will know already why this is an important case, and why the idea of the presumption of innocence is so heavily citing of this case. But for those of you who don't know, we'll go through it here. So, the facts of this case are as follows. It was a case which concerned the conviction of murder of an individual by the name of Mr. Woolmington. I believe his first name was Reginald Woolmington, and he had split up with his wife, or his wife had left the sort of the matrimonial home, and she had decided to go back and live with her mother. Now, Mr. Woolmington then went to her mother's house, where she and her mother was, at which point a series of events will take place, and it will end up with the shooting of his wife and killing her. So he goes to her mother's house, should I say, with a shotgun, and I believe it's a sawn-off shotgun specifically, and at which point she ends up getting killed. She ends up getting shot and killed. So there is a conviction of murder that takes place here. He had claimed that the reason he had gone to the house with the shotgun was that he was going to threaten to shoot himself in order to get her back. Basically, come back with me or I'll do it, essentially. And that the shooting of her was accidental. Okay, he didn't mean for it to happen. Now, a couple of things that need to be noted. Firstly, the idea of accidental shooting, it was an accident, okay, does not provide a defense to murder in the criminal law. What it does is it negates the mens rea of murder, because of course murder has to be the killing of an individual with an intent to kill or to cause grievous bodily harm. If it was accidental, then it would therefore result in the fact that this would negate the mens rea of that particular offence. So this is what we have so far. Now, the thing that's important for the case of Woolmington, however, is the way in which at trial, the judge and I believe also at the Court of Appeal, the judge presented the nature of the presumption of innocence. Because at the level of the Court of Appeal, it was held, in fact, that there was a duty on the part of the defendant to show a negating of the mens rea for Mr. Woolmington. He was presumed to have the mens rea for murder, and it was apparently up to him to show the opposite, to show that he had not got that, did not have that mens rea. Okay. And the reason why the Court of Appeal went for this sort of approach was because on their account, and in their minds it seems at least, that the case for murder was so clear-cut that it was not, in fact, up to the prosecution to show the murder, it was up to Mr. Woolmington to show that it wasn't murder, all right? Well, of course, you might already be thinking, well, this is a little bit silly, because at the House of Lords level, the appeal was allowed on account of Mr. Woolmington at the House of Lords, where it was in fact concluded that the burden of proving the actus reus and the mens rea of a particular offence, in this case we were talking about the offence of murder, rests solely with the prosecution and not with the defence. And this is where we get the famous golden thread passage, where they say, quote, "Throughout the web of English criminal law, one golden thread is always to be seen, that it is the duty of the prosecution to prove the prisoner's guilt, to prove the guilt of the defendant. No matter what the charge or where the trial, the principle that the prosecution must prove the guilt of the prisoner is part of the common law of England, and no attempt to whittle it down can be entertained." So in this case, it was already assumed, And it was already a basic principle of law that there was a presumption of innocence, and there was a burden on the part of the prosecution to show to the legal standard that the defendant had acted in the way that was made them guilty. That was already a sort of principle that existed. But in this case, there was a sort of attempt, if you will, using the language of the judge here, to whittle down this basic presumption, to whittle down this presumption of innocence, to whittle down this burden. And so they really, flipped this on its head and said that no, this is a golden thread. This is a golden thread that is seen throughout every single case within the English criminal law, or the web of English criminal law. And no attempt to whittle it down should be and can be entertained.